Yes, I do, Your Honor.
Okay. You have an attorney representing you?
Not at this time, but I am an attorney myself.
Mhm. Well, do you would you waive service this matter?
I would be glad to waive service, Your Honor.
You wish to file any responsive pleadings?
Not at this time.
All right. Any other parties, anybody else thoughts about this status here now?
Your Honor, this is Adam Sparks, Representative Roberts. I don't mean to jump whatever agenda you have prepared for the hearing, and I'm happy that Ms. Silcox is available to participate. I must say that your point about her not being served in accordance with the contest statute does dovetail with arguments we've already submitted in our proposed now docketed motion to dismiss concerning appropriate diligence and prosecution of this contest. Again, I don't wish to jump your agenda, but I did want to note for the record, we had some of the same concerns.
All right, well, thank you. And just a couple of, I guess, matters that I had noted, and I think Sparks read through this week in your filings, the affidavits that were the two Jane Doe affidavits that were filed. I mean, I think pretty clear court's not going to consider anonymous affidavits in a case. And there was a note in there about, the court could do an in-camera inspection. Well, I mean, that's, I mean, the parties need to be aware of who's alleging facts to their personal knowledge. So that, I mean, those are not going to fly as this case goes forward. So I get those initial, again, the service was the big issue. So I guess that's cleared up. And so yeah, now we have the filing a motion to dismiss. I guess, I mean, if Mr. Kaufman and Mr. Smith, I assume that y'all would want some time to respond.
That's correct. We would want the proper to respond.
How much, and again, I mean, this case, I don't know what the delay was on as far as getting it out to the named parties be served. But again, I mean, this case has been sitting with nothing going on for months, and no, like I say, and then apparently no effort to get the candidates served.
Your Honor, this sounds Kaufman. I want to correct the record. We have repeatedly asked the Fulton County Superior Court to have affected the statutory service. In fact, there's multiple emails requesting it. It seemed that the clerk was unaware of her statutory duty of what it meant for her to be the one to participate in that service, that special service.
Well, I thank you, Mr. Kaufman. I say from what I've seen in the record as far as the service, and again, maybe there's something in the request in there about getting the two candidates served. I've seen nothing that's in the record about any efforts by the plaintiff to see that those two necessary parties were served in the case. All right, well, let's see, the Mr. Kaufman, Mr. Smith, the plaintiffs, all that. What's the status from y'all standpoint of where? I mean, I assume you want to continue on with this case. I mean,
yes, Your Honor. Actually, we've requested the court to give us discovery, which is in the court's plenary power. We actually have 802 affidavits of people that we believe voted improperly in effect this election, the affidavits that were in the initial complaint were redacted because they were subject to an SOS investigation at the time. We have 802 affidavits.
The first one, I forget how it's styled. That affidavit seemed to be dealing with differences in votes in the presidential election. Didn't seem to have anything at all to do with this race. And I don't know if the second affidavit had much of anything to do with this House race, but
these 802 are specific to House District 52.
all right. All right. Well, what about, let's see, Ms. Ringer, what's your thoughts on this case? From your county standpoint here.
Well, from a county standpoint, I was just trying to refresh my recollection. I am not clear, Your Honor, if the Secretary of State was served in this case. Can Mr. Kaufman let me know if that's the case? Okay.
Yes, Your Honor. The Secretary was served and is well given the statutory overnight per 21 to I believe 524, as well as the State Election Board.
Okay. Well, the Secretary of State is the chairman of the State Election Board. So I was checking for that. With respect to the affidavits, I would have to agree with Your Honor about at least what was filed in the initial complaint. We will get more information from plaintiff's counsel with respect to the information or the affidavits that they have. And once I have that, I'd probably be able to respond more thoroughly. But yeah, I would note, even though they were redacted, I had some concerns about some of the affiants because I believe they're actually plaintiffs in another case. The statements look very similar to statements that I've seen in another case. And so I'm was a little bit concerned that they were redacted, but Your Honor has spoken to that.
Mr. Sparks?
Yes, Your Honor. The motion for limited discovery and subpoena power should be dismissed by this court out of hand, respectfully, for a number of reasons. One is the lack of diligence of service that we've already begun to address. For another, we do have a motion to dismiss on the docket. If one were to apply the Civil Practice Act, as the Martin case would countenance that this court may, discovery should be stayed for 90 days or until the motion to dismiss is resolved per OCGA 91112J. So there's no reason to proceed with discovery of any form. Even if we were to proceed with discovery, while I submit that in that case, the petitioner would be authorized to issue requests for production of documents or other tangible things, there's no reason to permit petitioner to arrogate the court's plenary authority to issue subpoenas or to compel the attendance of witnesses under 21-525 paragraph B. That power belongs to the court, not to the petitioner. And in any event, if petitioners claim they already have north of 800 affidavits that they claim are relevant and material to this particular dispute, it doesn't appear that they need subpoena power of any kind to go about trying to gather some sort of evidence that would buttress their allegations in any way. So for a number of reasons, I would respectfully request that the court deny the motion, preferably with prejudice along with the case. But if the court's not so inclined, then certainly to deny it at this time until the motion to dismiss is ruled upon at a minimum.
Your Honor, the issue with the subpoena power is that we would need it for admissibility purposes for some of these affidavits because they involve certain government records that we do not have the originals or under 8036 or 8038. And we, if the court is willing to waive that aspect of the Georgia Civil Practice Act, which we contend does not apply, we'd be able to proceed much faster. But we do believe that some limited discovery, especially of a case of this importance, would be warranted. And we obviously reject the allegation that we were not diligently trying to have service perfected. But of course, we can't control either the Fulton County Sheriff or the Fulton County Clerk of Court to issue the special service.
All right, well, like I say, we take a look, see what efforts you made to get the two candidates served. Yes, like I say, this is a unusual law, the different aspects than Civil Practice Act as far as service, but it's pretty straightforward on what needs to be done. All right, anybody have any parties have any other issues or concerns right now that you wish to raise for them?
Your Honor, Mr. Sparks or Representative Roberts, I realize we do have a pending motion to strike as well. It appears there was another amended affidavit filed moments before this hearing began. I have not had time to review that in detail, let alone discuss it with my client, but certainly I will review it after this hearing, and I would ask this court's leave now to file an amended motion to strike should we find that affidavit is also faulty. Do I have your court's permission for that?
Yes, like I said, Mr. Sibley, just for that, I pulled it up, but like I say, as the hearing was started, haven't had a chance to look at it either. All right, well, I think right now, yeah, and Mr. Smith.
Also, Your Honor, we are going to be filing a motion to disqualify the law firm that's going to be representing the defendant in this case, not Fulton County, but the candidate defendant for a number of reasons, but we'll be filing that here shortly. So that will be on the docket as well.
All right. Well, again, looks like there's a number of things, several things that need to be addressed then before we're in any real position to move forward in as far as any substances evidentiary matters. All right. So I guess right now I need to, how much we need the plaintiffs to be able to respond to motions, defendants Roberts' motion to dismiss based on the alleged.
Your Honor, if we could have a week to 10 days, that would be terrific.
Right. Well, let's say 10 days, and actually, and then you file your motion to disqualify. Maybe give 10 days to respond after that's been filed. I'm not gonna make any ruling on discovery right now. We'll see after responses to the motion to dismiss and motion to disqualify, and then see where we are after that as to going forward on any discovery. In the meantime, it would. I want to have, if you want to, plaintiff wants to provide to defendants the affidavits that you have now, whether that would be might be of some assistance in moving it forward for everybody. I don't really need to file it with the court right now, but if you want to share it with each other at this point.
We're willing to share those affidavits, Your Honor.
Okay. All right. Like I say, just do that between yourselves, and then if it needs to be filed, they need to be filed with the court at some point, then that can be done.
Your Honor, if I may.
Yes, ma'am.
We would like the opportunity to consider whether or not we'll file a motion to dismiss. If we were to do that, we would do it today.
Okay.
And then parties would have 10 days to respond. Would that be consistent with your order?
That would be fine. Yes. So whatever, all the three, well, the motions, the existing motions dismiss and 10 days, and then whatever gets filed, motion to disqualify, maybe an additional motion to dismiss affidavit, the amended affidavit, county's motion to dismiss, file those, and then the other side will have, say, 10 days to respond to that. And then we'll see where we go from here. Now, just from a time standpoint on this, like I say, I want to do everything I can to move this case on as expeditiously as we can. But I'm going to be sitting in DeKalb Superior Court all of the week of April 5th, and then I've got a daughter and son-in-law and granddaughter coming into town the following week. So I'm the next couple of weeks are pretty booked up as far as doing anything. So we can look at motions and discuss as far as any lengthy hearing or anything. It's going to be a bit before we'll have time to schedule that. So.
Your Honor, also, we're going to ask for leave to amend the complaint as well.
All right, I'll grant that.
Thank you.
Needs to respond, Marcus, if anybody wants to respond to that.
Yeah, Your Honor, for Representative Roberts, I'm a bit wary of an open-ended, at least from our perspective. Obviously, our consent is not necessarily required, the court's is, but we would oppose an open-ended grant to amend the petition as it is. As Your Honor has noted, it's been 4 months since this was filed. If there's some sort of recent development for which they would like to amend the allegations, that's certainly understandable. But simply to go back and fix deficiencies that have been sitting there for 4 months and unserved for 3 does give me a little bit of heartburn, I must admit.
Your Honor, we've actually recently obtained new evidence that is technical in information. It is using telephonics tracking data, having particularly to do with Dropbox in this district. And so that's one of the things that we would like to use to amend the complaint. They would also likely address any of the alleged deficiencies on the motion to dismiss, which would make them all nullities.
I'm sorry, you kind of went blurred, and also address any of the deficiencies.
We could address any alleged deficiencies. Of course, the code section says, that under section 21.2524F and E in particular, that the state of the ground shall not be rejected, nor the pleadings dismissed at any court, one of form, if the grounds of contest are alleged with such certainty as will advise the defendant of the particular proceeding for cause to which the primary election is contested. So we will address all those motions to dismiss issues as well. So hopefully that'll make this case be able to move along fast.
All right. Well, like I said, I'll allow that, and Mr. Sparks, understand your position on that. I mean, what has been, and nothing's going to change that. But if there's new evidence or whatever to be considered, we'll go along with that. When do you, Mr. Coleman, Mr. Smith, when do you think you'll be filing that amended?
This week, Your Honor.
Okay. All right. Okay. All right. So I think we're all on the same page then of by your amended petition. If any of the defendants want to file any response to that, of course, it's amended to stand denied without any response. If anyone wants to file to that. Motions, existing motion, 10 days to respond to that. New motions, 10 days to respond to those after they've been served. And I'm going to withhold making any decision as far as discovery until after we've dealt with these existing and to be filed motions then. All right.
Thank you, Your Honor.
Anything else from anybody else? Any thoughts?
Your Honor, are you going to issue an order based on all that today, or?
Yes, we can go ahead and do that. And what about Ms. Silcox? Should we have something?
Your Honor, we'll prepare an acknowledgement for Representative Silcox.
All right, that'll be good. Okay. All right, and then and y'all have already been in contact with Mr. Sibley, the staff attorney, who I couldn't be doing any of this without. So you're continue to work through Mr. Sibley on this, and
He's doing a terrific job, Your Honor.
oh yeah, he's
Amen.
as I say with staff attorney, I'm like the Wizard of Oz. Pay no attention to that man or woman behind the curtain. I'm the great and powerful Oz. Hey, what do I do now? So yeah, all right. Well, we'll get those going and say I'll do the best I can to move this on as expeditiously as we can. Okay.
Thank you.
Right. Thank you, everybody. All right. Have a good day then. Thank you.
You as well. Thank you, Your Honor.
Thank you.